Good afternoon, ladies and gentlemen. Welcome to Civil Justice Subcommittee for Tuesday, February the 20th, 2024. Madam Clerk, take the roll.
Good afternoon, Representatives Bolsa, Capley,
Yep.
Eldridge, Farmer, Grills, Lamberth, Todd, Chairman Russell, Representative Parkinson. Chairman, you have a quorum.
Thank you. Members, are there any personal orders this afternoon? All right, seeing none, just a reminder for all members, if you vote in the opposition and wish to have your vote recorded as such, check with TJ and have your vote recorded. We'll start with the calendar. Item number 129, House Bill 2919, rolled 1 week without objection. Item number 3, House Bill 2113, rolled 1 week. Item number 4, House Bill 2216, rolled 1 week. That was number 4. We already did number 3. Item number 5, House Bill 2689, rolled to the March 19th calendar, and we have an objection. Chairman Farmer, let me be recognized.
What's objection is to vote on the motion? It's probably going to be for a motion. Let me just say, yeah. No, they don't need to.
We're going to take a short recess. Give us just a second. All right, we're back in session, and Chairman Todd, you are recognized.
Thank you, Mr. Chair. I withdraw my objection.
Okay. Without objection, item number 5, House Bill 2689 is rolled to the March 19th calendar. Item number 6, House Bill 2032, rolled to the March 19th calendar. Item number 7, House Bill 2035, rolled to the March 19th calendar. It brings us back to item number 2, House Bill 2120 by Chairman Faison. Chairman Faison, do we have a motion? We got a motion and a second. Chairman Faison, you are recognized.
Thank you, Mr. Chair. Mr. Chair, I do have a technical amendment from TDEC on this. Would you like to?
Yes, sir.
Do you want me to proceed and talk about the bill or take up the amendment
What's
first?
your amendment number? We'll go ahead and put it on.
I've got 13928.
That's what I got. Members, we're voting on. Do we have a motion and a second on the amendment? I'm sorry. Could you describe the amendment?
Absolutely. Thank you. Members, Mr. Chair, this bill is to take out from the definition of public use as it deals with eminent domain, take out parks and recreation. Right now, you can use eminent domain for the word public. In public use, you can use parks and recreation. So what we're doing is just separating that and saying you can't take land for public use if it's for parks. And the amendment takes out brownfields and state parks. That's all the amendment does.
Thank you, sponsor. Members, you've heard the explanation of the amendment. Do we have any objection for adding it to the bill? Without objection, we're voting to add Amendment 13928 to House Bill 2120. All those in favor signify by saying aye. Opposed, no. Amendment added. Chairman Faison, you're recognized on the bill.
Thank you,
as
Mr.
amended.
Chair. Committee, you'll remember last week we had a gentleman from my county, Jefferson County, come and present the notion of what eminent domain was going to be used for in my district. We're trying to put some guide rails on there. While we're putting guide rails, when you look at the TCA currently, when it says you can take property for public use, inside of that terminology, public use, the TCA recognizes recreational or parks as public use. I personally believe that for eminent domain, it should typically go where the infrastructure and roads and highways and such as that. And this was voted on by my county commission to put some guide rails in there. And that's what this bill does. It only deals with taking land for recreational use.
Very good explanation. Do we have any questions for Chairman Faison, Chairman Farmer?
Yeah, and thank you, Mr. Sponsor, for bringing this piece of legislation. Just wanted to add also, this doesn't just, it's not cut and dry saying that a municipality or a county couldn't do this. Isn't it fair to say that within this bill, there are guidelines to where property could be taken? They just need to look to see to make sure there's not some other properties available.
Right.
And things like that. I mean, there just needs to be some due diligence done. And if, for example, if this is the only place this can go and there's no other place like that's feasible and everything's worked out, then they move forward, right? Is that not the intent or the actually the written?
And you're all welcome to go back and forth.
Legislation.
Thank you, Mr. Chair, committee. This bill deals specifically just with the use of eminent domain when it deals with recreational purposes. There's two bills. We're talking about the bill we passed out of subcommittee last week. So when you were just questioning about, this one only deals with public use and recreational facilities.
Okay.
Chairman Todd, you're recognized.
Thank you, Mr. Chairman, and I appreciate you bringing this bill. I mean, I certainly see cases with eminent domain across our state, and there are necessities for that. But if there's a question about whether we should do something or not, you're on the fence, then we need to side with the side of property owners and their rights more than just some maybe. I mean, we've heard other states that have had literally exercise eminent domain to improve a piece of property and put some commercial aspect there, and that's absolutely wrong. And so we don't ever want to approach that. So I appreciate you bringing this bill.
Thank you. And Representative Bolzo?
Thank you, Mr. Chairman. I've got a question for legal when the time is appropriate.
All right, without objection, we'll go out of session, speak with legal.
Thank you.
Legal, Representative Bolzo, you're recognized.
My question, Ms. Ansonia, deals with how this bill would affect 29-17-201.
And y'all are welcome to go back and forth.
As I read 29-17-201, it says that counties are empowered to condemn and take property, buildings, privileges, and rights and easements of individuals and private corporations for any county purpose. And so 29-17-201 doesn't use the term eminent domain. It doesn't use the term public use. So if I'm reading 29-17-201 correctly, even if this were to pass, counties would still have the ability to condemn property for parks and recreation. And my question is, am I right about that or wrong?
Elizabeth Ansonia, Legal Services. I think that a possible conflict between those two provisions would have to be resolved by a court. They may find that this bill amends that that statute by implication, but they may not. That would be up for a court to determine.
Any further questions for legal?
Just one more. If
You
I could,
recognize.
Ms. Ansonia. 2917-201 uses the term county purpose. Is that term broader or more narrow than the term public use as defined in the proposed bill?
Representative Bolzo, I'd have to research that issue and the case law surrounding it more before I think I could give you a competent answer on that, but I'm happy to do that and get back with you.
Thank you.
Thank you. Any other questions for legal? And Chairman Faison, do you have a question for legal?
No, I
A
have an answer
response.
for that.
Go ahead with your response. Well, actually, let's go in session and then you'll go. And Chairman Faison, you're recognized.
Thank you, Mr. Chair. Committee, not at all wanting to answer for legal, but from my understanding, House Bill 2120 rewrites 2917. And so since it rewrites 2917, the sections that you're quoting, the new language will be what that bill you have in front of you now, House Bill 2120. That's my understanding of what we're doing.
Representative Bolzo, you're recognized.
Thank you, Mr. Chairman. And I think that that probably is not true, because what the bill does is it creates a new definition for the term public use. It contracts it so that it excludes parks and recreation. But when you look at 2917-201, which the proposed legislation does not affect, it says counties can condemn property for any county purpose. It doesn't use the term public use. And so I think even if this were to pass, I think a court looking at the statute as revised would still conclude that a county can use the power of eminent domain to take property for a park or recreation.
Chairman Faison.
Thank you, Mr. Chair. And Representative Boso, I would encourage you to look at, I don't know the legal term, but from what I understand, courts look at what is the furthest down in the TCA to decide. There are times that the TCA looks like it disagrees with each other, but whatever's the last thing underneath it is what the courts go with. That's what I've been told in my 14 years of being here. Is it subrogation? Is it not subrogation? I can't remember the legal term, but whatever the most recent thing is underneath the TCA, that's what the courts decide on.
And could I get Leader Lambert to chime in here?
Yeah, I think what my colleague from Williamson County is trying to say is that I think you would potentially need to change both sets of statute, and then you don't have a problem anymore. Right now, we're just changing one definition, and the other one is it's remaining silent on it, which creates a conflict there. Now, who knows what a court would do with that, but I don't think you'd want your legislation just left in the hands of a judge somewhere down the road when dealing with something as important as eminent domain. True, Bill, but at the same time, I think it would be probably beneficial to change both sections if you want to make this particular move.
Chairman Faison.
I'm completely good. If it's possible to get this amended to do that, I don't know if this caption is capable of doing that, but if it is, let's.
Would you like to take it off notice to take a look at it?
Yeah, good idea.
All right. Without objection, item number 2, House Bill 2120, off notice. All right, members, that brings us to item number 8, House Bill 1906. We got a motion and a second. Representative McCallum, you recognized. And we do have an amendment. Do you still want to run your amendment? We got
Yes,
a
sir.
motion on the amendment and a second. What's your amendment number?
Chairman, thank you. That is drafting code 013397.
That's exactly what I show. Without objection, we're voting to add 13397 on the House Bill 1906. All those in favor signify by saying aye. Opposed, no. Amendment added. And you're recognized.
Thank you, Chairman. Members, this is this bill speaks to the statute of limitations, civil statute of limitations on victims of human trafficking. What it does is it extends it to 30 years past the 18th birthday for a victim who's been trafficked to go back and claim recompense civilly against the horrible person who committed these acts upon them. And with that, I stand ready for questions.
Very good explanation. Members, we have any questions? Question's been called. We're voting to send House Bill 1906 to civil full. All those in favor signify by saying aye. Opposed, no. The ayes prevail. Civil full.
Thank you, Chairman and Committee.
Congratulations. Next up, item number 9, House Bill 1830 by Chair Lady Littleton. We got a motion and a second. Chair Lady Littleton, you are recognized. And I do not show any amendments.
Thank you, Mr. Chairman and committee. This is a very simple but very important bill. It creates one additional circuit court in the 23rd Judicial District.
Very good. You have somebody that'd
I
like to
do, I do.
testify? Without objection, we'll go out of session. And Judge Wolf, if you'll come up and make sure your red dot's on there. And you'll have 3 minutes. Just identify yourself to the committee, and as soon as you start talking, we'll start timing.
Thank you. I appreciate the opportunity to be here today, and thank Representative Littleton. I'm here for the citizens of the 23rd Judicial District, not for the judges, not for the lawyers. I'm here for the citizens who are having to wait due to a backlog of cases. I left court today in Charlotte with a 52-page criminal docket I could not get to in time to get here, not get through. Right now, we have 4,622 circuit criminal cases pending in the 5 counties. We have 642 circuit civil cases. We have 2,398 chancery or domestic relations and probate cases. That totals 8,304 cases for 3 judges. And the 3 judges hear both circuit, criminal, civil, and chancery, including all of the domestic relations matters. As a result, we then rotate across the 5. We actually ride the circuit, and we go in, and I hold a term of court every 6 months in each county. But as a result, the average wait for in chancery court in our district for temporary motions from the date of filing a divorce case until they can get a hearing is 20 to 40 days. An average domestic relations case carries 6 to 8 months to get anything heard in it. And contested divorces that will require extended hearing are 18 to 24 months. And if a judge has a conflict that they can't hear that case, it's going to be even longer. Major civil litigation, such as malpractice cases requiring weeks, wrecks our docket. We've had 2 major cases that I was presiding over, the State versus Wiggins, which is the Deputy Baker's murder, and State versus Joseph Daniels, which is the so-called Baby Joe case, both of which took 2 weeks at a time, and both of which basically resulted in a huge backlog of cases that could not get heard. Our criminal dockets are even more backlogged than the civil dockets. And right now, I have one major drugs conspiracy case that I've got to trial later in the month of March that has 27 defendants that we're trying to figure out how to try that. We have a serious criminal case, has a wait time of 18 to 24 months. We just tried an attempted first-degree murder case against a police officer over in Houston County that took 18 months from the date the crime was committed till we could get it tried. The Daniels and Wiggins cases took 3 years to be able to bring the case to trial. Some of these cases are almost 4 years that they are. We run the risk of having a violation of due process for these defendants and a speedy trial rights for the defendants. But more importantly, we also are not cognizant of the victims in these cases who are waiting for years at a time to have their day in court to express their reasons why. The problem is, for example, in my March docket in Dixon County alone, I have 43 felony trials set on 8 days that I'm able to give because I have to give days for docket calls and civil litigation. So we have 8 criminal trial dates, and we have 43 felonies set for trial and 30 misdemeanors set for trial.
Judge Wolf, that's your 3 minutes, but we've got unlimited time for questions. And members, you've heard the testimony, and Representative Kepley.
Could you please continue?
Judge Wolf, you're recognized. Just make sure your red light's back on. I cut it off.
Yeah. So, and I tried to speed up. But we have 6 to 7 a day in some criminal cases and 11 to 12. And what happens is these people know that, and I'm not being critical, the defense bar knows this and the defendants know it. They know that if they're number 7 on a day when there are 12 cases set for trial, they're not going to likely have to worry about getting ready for trial. So when we try 1 per day, the rest of them get bumped. And when I have my next term of court will be 6 months down the road, unless I can set aside some extra time. What ends up happening is they are waiting 2 or 3 years to get their cases heard. And while the defendants have a right to a speedy trial, the victims also are waiting to get their justice in the cases that they have a victim in. We're working to reduce that backlog. We're working hard to try to get as many cases as we have. We fill up our extra time with trial dates. But in my opinion, I'm here today because I think the citizens of the 23rd Judicial District deserve better. And I think that giving this a fourth judge would help us to create a situation where the victims and the defendants and the people who need to get domestic litigation heard and decided quickly rather than wait. I had a lawyer tell me about a woman who has need for a double or a knee replacement surgery, and she's got a pending case in a divorce case that has money on in the clerk's office that would help pay for that surgery, but she cannot gain access to it because she can't get a hearing date in front of a judge quickly enough to get the surgery done. So she's had to continue her surgery in order to get that surgery done after she can gain access to it. And it's simply because we don't have enough judges. We thank you for giving me the opportunity to speak. I'll be glad to keep talking about how bad things are. Anybody else have any questions? So.
Thank you, Judge Wolf. And Representative Kepley, got any follow-up to that?
Thank you, Mr. Chairman. Thank you for your explanation.
Thank you. And Chairman Farmer, you're recognized.
Thank you, Mr. Chair, and thank you for being here, Judge. It's always an honor to be in front of an honor. If we could you let this, and you kind of hit on it indirectly with some of the members of the committee. So you were talking about divorce cases. I don't know if you mentioned order of protections, and I know you were talking about criminal court and you're talking about criminal cases. So with regards to that, so I'm guessing your judgeship, does that allow for civil and criminal jurisdiction?
I do everything.
So you do everything.
One day I'll hear a criminal case, a first-degree murder case, and then 2 days later I'll be here trying a contested divorce. I've had 55-page criminal docket today. Those I couldn't get to, I've rolled over to tomorrow. Thursday and Friday, I'm trying a contested divorce in Cheatham County, even though this is not my term in Cheatham County. But I've given those dates out to try to give those people an opportunity. So what happens is, yes, we hear criminal cases, but we also I hear probably an equal number of divorce cases. And those include orders of protection, because if there's a pending divorce action, our General Sessions Court transfers those order of protections to that. We also hear will contests, probate matters, everything else. And so it's not just a cut and dry where I do only criminal things or even civil claims. I've also presided over a medical malpractice case a year or so ago. And those are time consuming too. But the civil litigation suffers, and that's the reason I guess I was emphasizing it. I may not have made that clear. Civil litigation suffers because there are not enough days, and we are by precedent and the preference that's given to criminal defendants having their day in court takes away from the ability to give as many days to civil litigation. So people who are wanting to get their divorce case heard or even a temporary custody hearing oftentimes have to wait because they can't get a date because of the criminal cases take precedence. So, but yes, we hear orders of protections, we hear divorce cases, temporary motions, and things like that. So.
And Mr. Chair, if I may.
Oh, absolutely. Y'all go back and forth.
And it sounds like you're postured very similar to the judges in the 4th Judicial District. So, and something I do want to emphasize is that what we don't see is the work that Judge Wolf and other judges similar situated as he, in the preparation, he mentioned a medical malpractice case, extraordinarily complex. You can get into divorce cases that are extraordinarily complex. You're talking about capital murder cases. I mean, all the time it takes in the office reviewing pleadings, motions, and preparing judgments and opinions. It all takes time. And I just want the members to know, and if you have anything to add to that, sir, I'd be happy to hear from it.
You can ask my wife back there about the time that it takes in preparation, but also about preparation of orders, because there are many of these kinds of cases that you have to take under advisement because our appellate courts require a specific written findings of fact and conclusions of law. And if they're in a summary judgment motion in a complex case, then you have to do a written order that takes time. You can't just sit down and in 30 minutes knock one out. You have to review the file and everything. So yeah, those things are as well time consuming. But my practice is I try to look at every file before I go into court and hear that case, and that takes time away too. So it's just a matter of having enough hours in the day to get everything done that we need to do. Having an extra judge that we've needed now, according to the weighted case logs study that the Administrative Office of the Courts puts out, we've been in need of a judge now for a couple of years. But having an extra judge would give us the opportunity to give more days for those people who need it, especially in civil litigation. So.
Thank you. That's all I have, Mr. Chair. And thank you, Judge Wolf.
Thank you. And Leader Lambert, you're recognized.
Your Honor, thank you for being here today, and I appreciate Chairman Littleton fighting hard to get another judgeship in your area. You definitely need the support of, quite frankly, the 23rd, 18th, 4th, and 19th all need an additional judge, and the weighted caseload study needs to be updated. I'm sure there are other districts that are in need as well, but y'all's is definitely at the top of the list and has been there for a couple of years. So I appreciate you valiantly soldiering on as Chairman Littleton and others fight to try to get another judgeship there for you to get a little assistance. So just wanted to say publicly thank you, and thank you to the chair lady for fighting try to make this happen.
Well, Mary, as I call her, because I know her personally, but Representative Littleton has worked hard for us. And if I don't care enough to come up here and speak on behalf of that, then I don't deserve an extra judge to help our people. So.
Thank you. And seeing no further questions, Judge Wolf, we appreciate
Thank
you
you.
being
I
here. We
appreciate the
appreciate
time.
your testimony. Without objection, we'll go back in session. And Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. I guess you can hear and listen to how bad we need a new judge. And like you said, it's not for him, it's for the people of or the 23rd Judicial District. So we appreciate any help you can give us.
Absolutely. Seeing no questions on the list, we're voting to send House Bill 1830 to civil full. All those in favor signify by saying aye.
Aye.
Opposed, no. Ayes prevail. Civil full.
Thank you,
Congratulations.
Mr. Chairman and committee.
Thank you. Members, seeing no further business without objection, we stand adjourned.